Howdy, howdy, howdy. We're back at it again with reading the Constitution Annotated. This was a tool that was released in 2019, and I just wanted to go over it and read everything that there is to offer, because if we do not know the laws of the land, we do not know what we are implicitly consenting to by not abolishing all laws that we do not readily consent to. If we are not actively working against them, we are implicitly consenting, so we have to know the laws in order to know what we do not like about them. So this is the analysis and interpretation of the U.S. Constitution that was originally intended for the members of Congress, but it has been made available to the public about 1964 in written form, and then to us in 2019 digitally. And it's a pretty cool resource so far, and we are trucking our way through the introduction materials because I want to read it the way that it was intended to be read, I reckon, because this is the order that they give it to us to begin with. So we're going to truck through it, we're going to read it, and we can always save some analysis for the very end after we have completed the project as a whole, and have that foundation. We can then build upon it later. So let's go ahead and swap over into this mode where I am able to give you this showing here. So this is proposed amendments not ratified by the states, intro 3.7. During the course of our history, in addition to the 27 amendments which have been ratified by the required 3/4 of the states, 6 other amendments have been submitted to the states but have not been ratified by them. Beginning with the proposed 18th Amendment, Congress has customarily included a provision requiring ratification within 7 years from the time of the submission to the states. The Supreme Court in Coleman v. Miller declared that the question of the reasonableness of the time within a sufficient number of states must act as a political question to be determined by Congress. In 1789, so basically someone was like, yo, can they actually submit this time? Is this relevant? And the Supreme Court's like, Congress can say if that's relevant or not. They can choose whether or not to put that provision when they submit it to the states. They don't have to, but if Congress wants to, they've been doing it customarily here. Customarily included the provision within 7 years. We see, woo. In 1789, at the time of the submission of the Bill of Rights, 12 proposed amendments were submitted to the states. Of these, Articles 3 through 12 were ratified and became the first 10 amendments to the Constitution. Proposed Articles 1 and 2 were not ratified in these 10, but in 1992, Article 2 was proclaimed ratified 203 years later, and the following is the text proposed in Article 1. So we learn that Article 2 was passed in 1992, and just from the last video we learned that this was this here. No long varying the compensation for the services of senators and representatives shall take effect until an election of the representatives has intervened. So, like, if you're elected to the position, you're not allowed to have your compensation changed until the next election when you want to bid for the role again. So, Article 1. After the first enumeration required by the first article of the Constitution, there shall be 1 representative for every 30,000, until the number shall amount to 100, and after which the proportion shall be so regulated by Congress that there shall be not less than 100 representatives, nor less than 1 representative for every 40,000 persons, until the number of representatives shall amount to 200, after which the proportion shall be so regulated by Congress that there shall not be less than 200 representatives, nor more than 1 representative for every 50,000 persons. Thereafter, the second session of the 11th Congress, the Congress proposed the following amendment to the Constitution relating to the acceptance by citizens of the United States of titles of nobility from any foreign government. So there was proposed the following amendment relating to the acceptance by citizens. The proposed amendment was not ratified by 3/4 of the states, and it read as follows. Resolved by the Senate and the House of Representatives of the United States of America in Congress assembled, 2/3 of both houses concurring, that the following section be submitted to the legislatures of the several states, which, when ratified by the legislatures of 3/4 of the states, shall be valid and binding as a part of the Constitution of the United States. If any citizen of the United States shall accept, claim, receive, or retain any title of nobility or honor, or shall, without the consent of Congress, accept or retain any present, pension, office, or emolument of any kind whatever from any emperor, king, prince, or any foreign power, such person shall cease to be a citizen of the United States and shall be incapable of holding any office of trust or profit under them or either of them. During the second section of the 36th Congress on March 2nd of 1861, the following proposed amendment of to the Constitution relating to slavery was signed by the President. The President's signature is considered unnecessary because of the constitutional provision that upon the concurrence of 2/3 of the Houses of Congress, the proposal shall be submitted to the states and shall be ratified by 3/4 of the states. We have here: resolved by the Senate and the House of Representatives of the United States of America in Congress assembled, that the following article be proposed to the legislatures of the several states as an amendment to the Constitution of the United States, which, when ratified by 3/4 of said legislature, shall be valid to all intents and purposes as part of the Constitution, viz. Article 13. Let's do a quick little aside here. What do we see this? What is this here? In other words, namely, alright, Article 13. No amendment shall be made to the Constitution which will authorize or give Congress the power to abolish or interfere within any state with the domestic institutions thereof, including that of persons held to labor or service by the laws of said state. Interesting. So this is like saying, like, look, it's states' rights to determine if people could be held to labor or service. So, I mean, it's kind of limiting the federal government's power. But if we can't guarantee that all of the states will make the right decision, because if it was all like an individual choice, no one would choose the slavery. And if they did, sure. If they are willingly saying, yes, I will be your slave, sure. Sure. We cannot, like, go against, like, personal wish. But, like, a state, we're putting too much trust in the state, the individual, like, bodies of government. It's not dissolved enough. It's not dissolved enough. Like, because if the individual does not want to be enslaved, they should have the power to control themselves. That seems so blatantly obvious to me as a citizen of 2023. I have no clue how someone could even imagine a world or a situation where they own somebody. That's kind of fucked up. In more recent times, only 3 proposed amendments have not been ratified by 3/4 of the states. The first is the proposed Child Labor Amendment, which was submitted to the states during the first session of the 68th Congress in June 1924 as follows. Joint resolution proposing an amendment to the Constitution of the United States, resolved by the Congress and yada yada. Alright, let's go ahead and read it. Resolved by the Senate and the House of Representatives of the United States and Congress assembled, 2/3 of each house concurring therein, that the following article is proposed as an amendment to the Constitution of the United States, in which, when ratified by the legislatures of 3/4 of the several states, shall be to all intents and purposes as part of the Constitution. Section 1. The Congress shall have the power to limit, regulate, and prohibit the labor of persons under 18 years of age. The power of the several states is unimpaired by this article, except that the operation of state laws shall be suspended to the extent necessary to give effect to legislation enacted by Congress. This section is why I wouldn't ratify it if I was a state. The power of several states is unimpaired by this article. I guess, okay. Unimpaired by this whole article because it defines section article, the whole article. So I'm being dumb. I was expecting, like, I thought this was a self-contained statement. So, okay. Limit, regulate, and prohibit the labor of persons under 18 years of age. I mean, that's kind of reasonable. Give people their childhood. The second proposed amendment to a failed ratification is the Equal Rights Amendment, which formally died on June 30th of 1982 after disputed congressional extension of the original 7-year period for ratification. Joint House Resolution 208, proposing an amendment to the Constitution of the United States relative to equal rights for men and women. Resolved by the State and Senate of House of Representatives of the United States of America in Congress assembled, 2/3 of each house concurring therein, that the following article is proposed as an amendment to the Constitution of the United States, which shall be valid to all intents and purposes as part of the Constitution when ratified by the legislatures for 3/4 of the several states within 7 years of the date of its submission by the Congress. Section 1. Equality of rights under law shall not be denied or abridged by the United States or by any state on account of sex. The Congress shall have the power to enforce by appropriate legislations and provisions of this article. This amendment shall take effect 2 years after the date of ratification. It's weird that didn't pass. What is the equality of rights under the law shall not be denied or abridged? That just seems intuitive. That seems intuitive. It's weird that wasn't in the original Constitution to begin with. That's weird. That's so strange. The third proposed amendment relating to the representation in Congress for the District of Columbia failed of ratification, 16 states having ratified as of 1985, expiration date for the ratification period. Joint Resolution 554. Resolved by the Senate and House of Representatives of the United States of America in Congress assembled, 2/3 of each house concurring therein, that the following article is proposed as an amendment to the Constitution of the United States, which shall be valid to all intents and purposes as part of the Constitution, when ratified by the legislatures of 3/4 of the several states within 7 years of the date of the submission by Congress. Article. Section 1. For the purposes of representation in Congress, election of the President and Vice President, and Article 5 of this Constitution, the district constituting the seat of government of the United States shall be treated as though it were a state. Section 2. The exercise of the rights and powers conferred under this article shall be by the people of the district constituting the seat of government, and as shall be provided by the Congress. 23rd Article Amendment to the Constitution of the United States is hereby repealed. This article shall be inoperative unless it has been ratified by the Let's pop on over there. 23. So it's appealing that, and it's just saying treat them as a state in whole. Treat them as a state in whole. Alright, wholesale state treatment is what I take that to mean. Let's see. Article 5 of the Constitution. Alright, so we have cleaned up here. That's pretty gorgeous. Let's go on, and we're gonna meet you in intro 4.1, overview of the Constitution, annotated methodology. We got some methodology to read, motherfucker. Motherfucker, 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 mother. I can always edit these to be more kid friendly. But bye for you.